Hello, my name is Neil Prevost, and I will assume that if you have found me and you're listening to this video, that you are the not so proud owner of solar panels and you're having troubles with either your lender or the system or all of it. And what I wanted to do is just tell you that I'm sorry you're in the spot you're in. I really wish you weren't. But we have found that you are not alone. There's hundreds and hundreds and thousands of people who find themselves in the same boat that you're in. And that is why our firm is dedicated 100% to nothing other than representing consumers against lenders in solar panel cases. Now, what I'd like to do for just the next few minutes is to go through with you and tell you about what we believe are the 5 most common things that we see in these cases. And if you have one or more of these, then you are likely to be a really good candidate to assert a claim against the lender. Now, you've heard me say lender twice. Let me first off the bat say the Federal Trade Commission promulgated a rule back in 1976. It's called the FTC Holder Rule. The Holder Rule says that you as a consumer, if the seller has sold the paper or gotten you into a loan on the product that you bought from them, that you can sue the lender for the sins of the seller. It's called the Federal Trade Commission Holder Rule. Google it. It'll explain all about it. But the Holder Rule allows us, because I started out on these cases trying to sue the sellers, but then I realized that all I really wanted the seller to do was write a check to the lender. So, because that's who you owe the money to. So if we want to go and get the loan paid off, then why not go straight to the source? And I discovered that that's the law. We're allowed to do that. So that's why you hear me talking about the lenders. So for a second, think about it as the lender and the seller are the same person, and I can go after the lender for what your complaints are, if you will, about the seller. So let me go through with you the 4 most common complaints about sellers, and then I'm going to talk to you about the last one about what the lenders themselves do. Okay. So the first thing that we see in these cases is what I call breach of installation warranty claims. This is where when they installed your system, they did it poorly, and either the system doesn't work, maybe it never worked, maybe it doesn't work to the capacity where it's supposed to be, maybe it didn't get permitted right. There's just all kinds of things that can go on with the installation. Then there's also installation damage. Does your house have a roof leak? Was there interior damage? Was there roof damage? Did they do something wrong in that installation that they have failed to fix or remediate? That would be a breach of contract, breach of warranty, and those are one of the most common things that we see. The second thing that we see is overall misrepresentations about how much you're going to save when you buy solar. Now, I hear it over and over and over again that when the salesman knocks on the door, the promise they make is you're never going to have to pay another light bill again. For the next 25 years, the only payment you're going to make is your loan payment. And they sell you, you believe them, you sign up, they put the system up, but those savings never materialize because there's a lot of state regulations about who gets paid what. It's not even possible in some of the states that we represent consumers in, it's not possible to even reduce your bill by more than 70%, even if your solar panels are producing 100% of your used energy. So this overall savings thing is a really big deal because when they try to defend the cases, they come in and they say, oh, it's producing everything we said it would produce. Well, it might be producing the energy they said it would produce, but it's darn sure not producing the savings they promised you. And when they're at your kitchen table, I doubt very seriously they talked about production. What they talked about was savings. And when those savings don't materialize and you're left in a worse position than when you started. And what I mean by that is if you add up your electricity bills before you bought solar, and then you add up your solar bill plus your electricity bill after you bought solar, it's so oftentimes you're losing money. You don't actually save anything on a monthly basis. those are good claims. And those involve a lot of deceptive practices and misrepresentations, which we can assert in your case. The third one is the misrepresentations that are commonly made about your income tax. They call it rebate. It's really a tax credit. It's not a rebate. What they don't tell you is that if you don't pay taxes, there's no rebate to be had. In other words, if you're supposed to get $14,000 back, if you don't owe $14,000 in income tax, you're not going to get any of the credit. So you're going to wind up paying 30% more for the system than you thought you were going to have to pay. Now, when you filled out your application, if you told them what your income was and you're on a fixed income, disability, retirement, or anything like that, and you make less than 150 or 200,000 a year, we think they knew or should have known up front that you were not going to get that tax credit, and that is an absolute misrepresentation and intended to mislead you and to bind this system so they can make a big commission. So those are great cases, and it's a case by case basis, but we see that a lot. The fourth item that we see is where you were sold a 10 to 25 year workmanship warranty. Now, there's two warranties. A lot of people don't realize there's two warranties on your system. One is for the panels, the inverters, all the mechanical equipment, and all of that. Those are guaranteed or warranted for 25 years from the manufacturer. But the other half of that warranty is the installation warranty, the labor warranty. Who's going to promise that my roof's not going to leak? Who's going to come fix it if my roof leaks because of the solar panel installation? And so a lot of these vendors that are selling say, oh, we're going to give you a 25-year warranty on workmanship and labor. And so you're covered bumper to bumper. You're never going to have to pay anything to keep these solar panels working and up to date. And, that's what you're buying, if you will, when you buy the system. Well, a year and a half later, they go bankrupt. They're out of business. And under the bankruptcy rules, it's a rejection of the warranty and it's a breach of the warranty as a matter of law. The day they file for bankruptcy, 60 days later, it's deemed to be a breach of the warranty. And you've got a good case for breach of warranty at that point. We might even be able to leverage that into what they call a failure of consideration claim, which means you don't have to pay at all. Or you get a pro rata reduction anyway of depending upon what state you live in, as to the total value of the warranty in the overall scheme of things. Most of my clients say it has to be 100% because I would never have bought the system if they hadn't have sold me on this big warranty. So those are great cases. Now, those are the four instances in which we can sue the lenders for the sins of the sellers. And then there's the last one I'm going to talk about is the sins of the lender and the seller, if you will. There's a thing in the industry called a dealer fee. And the main lenders that are in the industry, they all charge it. And what the dealer fee is, it's a 20 to 35% upfront payment off the top of the loan as an origination fee or a loan origination fee, or they call it a program fee. They call it all kinds of names, except what it is. It's a loan origination fee. And a loan origination fee has to be disclosed under Truth in Lending Act disclosures, which they never do. And so we believe that is a misrepresentation about the true cost of the system, the price of the system. Most of the agreements say, oh, we, the lender, we sent $60,000 to the seller on your behalf. Total lie. They probably sent $42,000 and they kept 30% off the top. And we believe that's a deceptive trade practice. Some arbitrators have already found that is a deceptive trade practice and that should come off the top of the loan as a matter of course. And we can sue the lenders directly for that. And that means there's no cap on either the damages that we might be able to get with regard to that claim or the attorney's fees. So those are the five areas that we see over and over again. And if one or more of these apply to you, then please go to solarpanelrelief.com, set an appointment, and let us evaluate your case to see whether or not we think we can get rid of your loan for you. In the meantime, we wish you the very best, and we really hope that we can get together and help you.